A brief history of special education before the 1970s judicial decisions. Before the 1970s, the laws in most states allowed schools districts to refuse to enroll any student they considered quote unquote uneducationable. Some children with disabilities were admitted to public schools and were placed in regular education with no special ed services, and some students were refused enrollment because of their disabilities. Around 1975, state legislatures and federal courts and the U.S. Congress spelled out strong educational rights for children with disabilities. 45 states legislatures passed laws mandating or finding special education programs. Federal courts interpreting the equal protection and due process guarantees of the 14th Amendment of the United States Constitution that the schools could not discriminate on the basis of disability, and parents had due process rights related to their children's schooling. Retitled the Individuals with Disability Education Act, or the IDEA. This helped with getting IEPs, parent rights, least restrictive environment for children with disabilities to provide related services. Parents pursued a second generation of laws known as quote-unquote mandatory laws. These laws provided partial funding. By 1973, there were 45 states that had passed some form of legislation for educating children with disabilities. In 1973, Public Law 93-112, the Rehabilitation Act, Section 504, provided that any participant of federal financial assistance included states and local education agencies must end discrimination of offering services to persons with disabilities. This was from the legislative and litigation history of special education. In 1990, Congress passed that Americans with disabilities by outlawing discriminatory practices in employment, public accommodations, transportation, and telecommunications. To find this out, you can go to the legislative and litigation history of special ed. The two court cases that I found were Plessy versus Ferguson, May 18th of 1896, Black versus Whites. The residents were agreed. The Brown versus Board of Education, May of 1954. The court hearing in 1896 of Plessy versus Ferguson, ban on race was found in violation of the 14th Amendment and Equal Protection Clause. And then for the Regents of the University of California versus Bake, was a white man denied access to University of California. In this, it was rigid use of the racial quotes and equal protection to the 14th Amendment. And that was in the National Constitution Center of Philadelphia, Pennsylvania. I believe that is all that I have. It is just crazy how the special ed kids were treated way back in the day, and now they at least have some rights where they can at least go to school and have outside services come in and help with their education if need be. Thank you very much.